Leading case 9L Chandra Kumar v. Union of India and others, 1994, 6 Suppl. This video delves into the significant leading case of L. Chandra Kumar your error. Union of India and others, 1994, 6 Suppl, which has had a profound impact on constitutional law and judicial activism in India. The case analysis highlights the judicial review and public interest litigation that has shaped the country's legal framework. The Supreme Court's landmark judgment in this case has been instrumental in protecting civil rights and promoting public welfare. This case study is essential for legal students and practitioners seeking to understand the nuances of constitutional challenges and judicial decisions. By examining the legal precedent set by this case, viewers can gain valuable insights into the role of the judiciary in shaping the country's legal landscape. Tune in to explore the intricacies of this pivotal case and its far-reaching implications for the Indian legal system. Hi, I am Advocate Dr. Chandra Kumar, bringing you a video on this fascinating topic like this. But before you start watching this video, I request you to kindly like, subscribe, and hit the bell icon to my YouTube channel. To view videos like this more, please leave a comment below, telling your thought and idea about this video and future videos you want. Kindly share this video with your friends, family, and social groups to spread this knowledge. Join me as I dive into the complexities of the Supreme Court's ruling on the Union of India case and try to break it down for you. This episode is all about the landmark case of L. Chandra Kumar v. Union of India and others, a significant milestone in the context of Indian constitutional law and judicial review. Today, we're going to explore how this case has shaped the balance of power between the judiciary and the executive, and what it means for the protection of fundamental rights in India. The case, L. Chandra Kumar v. Union of India and others, is a landmark judgment by the Supreme Court of India in 1997, not 1994, as cited in most references. It fundamentally dealt with the jurisdiction of tribunals in India and their relationship with the high courts and the Supreme Court. Key facts of the case. Should the petitioner, L.E. Chandra Kumar, challenged the constitutional validity of 9 Articles 323A and 323B of the Indian Constitution, which provided for the establishment of administrative tribunals and barred the jurisdiction of high courts over decisions of these tribunal. The primary grievance was that tribunals established under these provisions could effectively replace the high court's supervisory jurisdiction under Article 226 and N. Article 227 of the Constitution. Key issues. 1. Whether tribunals could replace the High Courts and Supreme Court in matters of judicial review. Whether barring High Court jurisdiction over tribunal decisions was constitutional. Court judgment highlights. 1. Judicial review as a basic feature. The Supreme Court held that judicial review is a basic feature of the Constitution and cannot be taken away. The power of judicial review vested in the high courts under Article 226, 227, and the Supreme Court under the Article 32 is an integral part of the Constitution's basic structure. 1. Tribunals jurisdiction. Tribunals created under Articles 323A and 323B could not be considered as substitutes for the high courts. Their decisions would be subject to scrutiny by the high courts. Articles 323A and 323B. The court declared unconstitutional the provisions in these articles that excluded the jurisdiction of the High Courts and Supreme Court over tribunal decisions. Supervisory role of high courts. High courts were restored to their role as the ultimate supervisory body for all decisions of tribunals. For impact, it reaffirmed the basic structure doctrine propounded in Keshavananda Bharati v. State of Kerala, 1973. Tribunals now operate as supplemental bodies to high courts but not as replacements. Ensured that individuals retain the right to approach high courts and the Supreme Court for judicial review of administrative and quasi-judicial decisions. If you'd like a deeper analysis of the judgment or its implications, feel free to ask. There is a problem in the Indian judiciary that the judicial mechanism is very slow, which led to a pile-up of cases in the courts. It becomes a huge burden on the courts to solve a large number of cases. That's why for a long time a mechanism was being searched to relieve all the courts from the burden, especially from that of service litigation, as it formed a substantial portion of pending litigation. So in 1958, the Law Commission submitted a report recommending to set up tribunals consisting of administrative and judicial members to decide service matters. Similarly, in 1969, Administrative Reform Commission, under the chairmanship of Justice J.C. Shah of